Good morning, everyone, and welcome. Thank you so much for taking some of your time out this morning to allow me to talk with you about something that most definitely will impact your planning for clients going forward. The Secure Act is largely understood to be the single largest impact to retirement accounts directly since the Pension Protection Act. And of course, the headline news out of the Secure Act is really the quote unquote death of the stretch, if you will. Now, the good news is that the stretch didn't completely die. It's still around for a number of beneficiaries, particularly legacy beneficiaries, as well as some eligible designated beneficiaries going forward. But the vast majority of beneficiaries no longer will be able to stretch if they're a non-spouse beneficiary. So let's go ahead and start there because clearly that is the most important news out of this. And Tim already mentioned this, but just as a quick frame of reference, if you want to ask questions, I actually have a Slido on a separate screen over here. So if you want to see what questions are being asked as you log into or as you put in that code, you'll see it and you'll see the full list of questions that are up there and people have asked already. I see 2 have come in so far, and you can either, as Tim said, ask your own or upvote other questions that you really want to see answered. And I am going to attempt to get through as many of these as possible. I would encourage you to, as you come up with your questions, put them in there because as I hit the slides where those questions are, I'm going to try and take them as we're on the slide. I think it makes things a little bit easier in this type of format. And also, if all of a sudden at the very end, 7,000 questions come in, I won't have paced myself correctly. So go ahead and type those questions in there as you have them, and I look forward to answering them. But with that, let's get to big change number 1. The biggest change, which is the death of this stretch. And let's start with an overview of where things were and where they're going today. So in the past, we had, broadly speaking, 2 categories of beneficiaries, right? We had non-designated beneficiaries, which if death occurred prior to the required beginning date, had the 5-year rule. And if death occurred on or after the required beginning date, it was remaining life expectancy of the deceased IRA owner. Now, we had, in addition to that, designated beneficiaries who got to stretch, right? So in the past, it was bad rules for non-designated beneficiaries, good rules for designated beneficiaries. The simplest way to think about the Secure Act's framework for the new regime is to imagine that the old rules, because they do, still all exist. So the rules that were here before still exist. The question is to whom they apply. So for instance, the first group you see here, the group of non-designated beneficiaries, there's no direct changes to their rules from the Secure Act. So non-designated beneficiaries still get either the 5-year rule or remaining life expectancy of the deceased IRA owner. Similarly, some beneficiaries still get to stretch using the old rules. That's a new category, which we'll talk about in just a moment, called eligible designated beneficiaries. And then finally, we have designated beneficiaries, which are our old group of beneficiaries that don't fall into this new eligible designated beneficiary category. Okay, so that's essentially our 3 categories going forward: is non-designated beneficiaries who still have the old rules, eligible designated beneficiaries who adopt the old rules of designated beneficiaries, and then designated beneficiaries who for the rest of our time together, when I say designated beneficiaries, what I mean is a designated beneficiary who is not an eligible designated beneficiary, right? By definition, all eligible designated beneficiaries have to they themselves be designated beneficiaries, but saying a designated beneficiary who is not an eligible designated beneficiary every time I need to say the word designated beneficiary is just a mouthful. So if I don't preface it with the word eligible, you can just assume I mean the designated beneficiary only who doesn't fall into that special category. And so with that in mind, virtually all of your non-spouse beneficiaries, save for a few exceptions, which we'll talk about in just a bit, fall into that new designated beneficiary category. And as you can see here, the general rule for those individuals now is a new 10-year rule applied very similarly to the 5-year rule that applies to non-designated beneficiaries when death occurs prior to the required beginning date. It's just twice as long. And so if you're not really familiar with that rule because you haven't had to deal with it yet or too often, which certainly would be understandable, right? We always encourage clients for the most part, not to have a non-designated beneficiary unless they're giving money to charity or something like that. Otherwise, we want named, living, breathing people on the beneficiary form or certain trusts that qualify as a designated beneficiary as well. So it wouldn't surprise me if you haven't really dealt with the 5-year rule before. So let's break into the 5-year rule and more importantly, how the 10-year rule acts like the 5-year rule, because the 10-year rule is going to be the thing that you deal with more than anything going forward. In short, the 10-year rule begins in the year following the year of death. So for argument's sake, today is January 30th. If someone dies today, then the 10-year rule for their designated beneficiary would begin in 2021. That would be year 1, 2022 would be year 2, 2023 would be year 3, and so on and so forth. However, during those 10 years, there's no required minimum distributions until we get to the end of the 10 years. So it's not like year 1, take out 1/10, year 2, take out 1/10, year 3, take out 1/10, or 1/10 the first year, 2/10. It's not. There's no minimum amount at all during years 1 through 9. If you want to take distributions, so be it, right? A minimum distribution is just that. It's a minimum. You can always take more, but there is no required minimum distributions during years 1 through years 9. All we have to do is get everything out of the account that's in there in year 10. And that's going to be an important distinction, especially when we get to the impact on trust here. We will spend a good portion, in fact, probably about half of our time together today, talking about the impact of the stretch, simply because of its incredible impact. And then we'll move on to the other issues that are apprised of the Secure Act. And one of the things that we'll discuss is the impact of these stretch rules on trusts. And it's really important to understand that the required minimum distribution for the 10-year rule is a one-time required minimum distribution in the year that is the 10th year only. It just says, whatever happens to be left in here, get it out. All right, so with that said, let's move on and talk about who these rules apply to. And unfortunately, it's most of your clients right away. Without getting political and saying, good, bad, and different, I will say this. One of the real disservices that Congress did was they kind of dawdled with this law for so long. It was in the hopper throughout almost all of 2019. In fact, in the summer of 2019, the House passed a version of the Secure Act, 417-3. It then had strong bipartisan support in the Senate, but sat there because they couldn't get unanimous consent to move it forward on a streamlined vote, and they couldn't figure out how else to bring it up on the floor in a timely fashion. So it just kind of stalled there until the very end of the year when it got attached to H.R. 1865, a year-end appropriations bill, which had, if you will, to be passed in order to keep the government open and funded, right? Otherwise, we were going to go back to another one of those government shutdowns, et cetera. And even though they passed this law on December 20th, or it was signed into law by President Trump on December 20th of 2019, they didn't change or push back the effective date for most of its changes past January 1st, 2020, which meant that essentially from nowhere, because this law was resurrected essentially from the dead, it was impacting clients just 11 days later. And think about this, right? It's 11 days later, including Christmas and no one had a chance to speak to all their clients between the time this bill got passed and when it actually began to impact people. There are trusts out there that will work absolutely horrifically today, which worked very well in the past, but who had time to meet with every client and identify every person and go to the attorney and redraft the trust, all since, there's a lot of people right now who are going to be in a lot of trouble. And sadly, as we've seen from horrific news just this week, death can come at any time. We don't know. We're a month into the year, 10% roughly of the individuals who are going to pass away this year have already died, and they may be impacted by these rules. So one of the things we'll do before we move out of the stretch area is try to prioritize, who you need to be reaching out immediately. Because in a perfect world, we'd snap our fingers and all of you would talk to all of your clients today to figure out how this impacts them. But the reality is, it just can't be done, right? You have to meet people one at a time. This is not a blanket situation that's going to be, hey, everybody needs to do this. When we get to our, how do we combat the death of the stretch area, every single strategy that we can use to deal with this change has some benefits and some drawbacks. And just like anything else, certain clients are going to value certain things more than other clients. So it's got to be an impactful, meaningful discussion on a client by client basis. And unfortunately, that's hard work, but frankly, that's what we get paid for, right? So that's the good news is there's more opportunity to add value. Now, having said that, even though it impacts most individuals who die after January 1st of 2020, and that frankly is one question that has been asked repeatedly is, what if my client died like December 31st, but we didn't set up the inherited IRA until today? Does that mean they lose the stretch? No, it's when death occurred. So if death occurred prior to January 1st, you're still okay using the old rules. Now, for a few different categories, the application of the death of the stretch, if you will, does not kick in until a later date. The first group there would be I'll start from the bottom up on the screen that you see here with annuitized annuities. And that is a permanent exemption, if you will, to the Secure Act's rules. In short, what this says is if you annuitized an annuity over a life expectancy prior to the start of this year, or a joint life expectancy, or if you selected an income option that was going to be irrevocable once it began. So for instance, think things like QLACs, qualifying longevity annuity contracts, where income hasn't really started yet, but you've made the irrevocable selection to start income at a later date based on a life expectancy or something like that. Those distributions are exempt from the new stretch rules. Next, from the bottom up, plans pursuant to a collectively bargained agreement. So if you're working with a bunch of union employees, the death of the stretch doesn't apply to those plans until January 1st, 2022, unless they renegotiate the CBA sooner. And then lastly, the one that is of probably biggest impact for most of you, and I think today is the 30th day of January, and I think today is also the 29th Secure Act presentation that I've done in January. So it's been a busy month. Bottom line is, in every presentation, wherever I've gone, and I know I can't see all of you now, but I would venture to guess that every single one of you has at least one client who works for either the federal government and has a thrift savings plan, works for a state or local government and has like a 403B account or something like that. You know, maybe they're a teacher, et cetera. I think it probably impacts every single one of you. The death of the stretch does not occur for those plans until January 1st, 2022. Okay, so January 1st, 2022, if you die before. Now, here's the good news, right? The good news is those individuals get 2 extra years in which to use the stretch if something happens to them. The bad news is, in order to make good on that exception, they have to die, right? So it's not the greatest exception in the world, although some people have pointed out the fact that, you know, Congress essentially gave themselves 2 extra years in this as part of being in a governmental plan, which is accurate, but again, it only really benefits someone if they pass away. That said, one of the things you may consider, and I'm going to get to kind of a strategy ahead of where we get to the strategy slide, but if you notice here, governmental plans don't have this impact until 2022. So one thing you may consider is, if you have a client that has a governmental plan, and let's say they're sick or ill, or they have, or frankly, they just want to, you know, say, what if something happens over the next 2 years? Perhaps we take their other assets, and if the governmental plan allows, we roll those assets into the governmental plan. And this way, if death occurs prior to January 1st of 2022, we preserve the stretch for everything, right? We preserve the stretch for everything. Now, presumably, clients may not want to do that because they don't like the investments of the plan, or they may have other reasons not to want to do that. And they may say, look, I'm 40 years old. Chances are nothing's going to happen to me in the next 2 years. I'm willing to take that chance. But if you know your client has this option, it's certainly something that you at least want to bring up and get on record, right? Document that you had that conversation. Just say, hey, if we did this, you might be able to preserve the stretch. But if you think it's not the right thing, explain why, right? But I don't think it's the best thing because chances are low, you're not sick, et cetera. If you get sick, we can always roll it in. It's only if you had like a car accident or heart attack, which is very unlikely since you're 40 years old, Mr. Client, something like that. Bottom line, just you want to have the conversation and justify potentially why you wouldn't roll money into the plan to preserve the stretch. All right, let's now talk about that new third group. Remember, kind of as a refresher to the first thing I mentioned to you, in the past, we had the 2 groups, designated and non-designated beneficiaries. Now we've got 3 groups. The non-designated beneficiaries kind of continue in their old vein. The group of designated beneficiaries now bifurcates into two groups. The new group of designated beneficiaries that don't meet the eligible designated beneficiary rules, which we just covered, has the 10-year rule, the brand new 10-year rule. And then we get to eligible designated beneficiaries, that brand new third group, which the simplest way to describe the rules for them is they get to pretend as if the Secure Act did not pass, right? It is business as usual for these beneficiaries as long as they are eligible designated beneficiaries. And you can see here the 5 groups. I'll go through kind of a couple key points for each of them just to highlight some of the key questions that have come in from advisors that I've spoken with so far since the Secure Act has been passed. But in short, fairly self-explanatory. For instance, surviving spouse, pretty self-explanatory. You've got to be a spouse. One question that's come up repeatedly, do domestic partners qualify? No, unfortunately, they do not. Disabled persons, how are we defining disabled here? It's disabled under 72M7 of the law. And if you're familiar with the disability exception to the 10% penalty, for instance, it's the same code section, 72M7. Why do I keep referencing that? Simply because it's a very rigid definition. It's not like I'm a surgeon, I cut my finger, and now I can't do surgery anymore. Or I used to work 40 hours a week, and now I can only work part-time. That doesn't fly. The definition of disabled under 72M7 says you are unable to engage in any substantially gainful activity, and it's expected to result in either your death or be of an indefinite duration, right? So it's a fairly restrictive definition. The best kind of one-to-one analogy I could give you for this would be if you don't think your client would qualify for Social Security disability, then they probably don't qualify under this disability exception either. Chronically ill persons, again, generally as defined by the tax code, you're all familiar with the regular definition here, which is just can't do 2 out of 6 ADLs, right? I can't, whether it be toileting, bathing, dressing, those type of things. If you can't do 2 out of the 6 of them, the only difference is where the tax code typical definition only says you're chronically ill if you can't do those, even over a short period of time. The Secure Act says you're chronically ill for purposes of an eligible designated beneficiary. If those impairments, if not being able to do 2 out of the 6 ADLs or more, is expected, similar to the disability rule, to be of indefinite duration or expected to result in death. So again, kind of severe. Then we get to this 4th group here, which is a beneficiary not more than 10 years younger than the decedent. And who is that? Well, frankly, it's anybody. It's anybody. That is, it could be a friend, it could be a brother, it could be a cousin, it could be some random person who just happens to be only 9 years younger than you. And so with that in mind, any beneficiary who's just within that 10-year age gets to pretend. No reason whatsoever. That's it. That's the rule. That's all you need to know. And then we get to the 5th one here, which is by far the most complicated for a couple of reasons. First off, there's been some confusion as to who exactly this applies to. And second, there's been some questions as to when the age of majority is. Because if you look here, it says the decedent's minor children. So first thing to note, the word decedent here is it's not superfluous, right? It's not just there because they decide. No, it's really important. It's not minor children. Minor children are not eligible designated beneficiaries. The deceased person's minor child is. So one question that's come up regularly is, so does this mean that grandma can still leave the IRA to the grandkids and allow them to stretch at least for some period of time? The answer is no, because when grandma dies, the grandkids are not her minor children. They're her child's minor children, right? And so that's an important distinction to be aware of there. The second is that minor children, unlike the first 4 groups we covered, so unlike surviving spouses, disabled persons, chronically ill persons, and beneficiaries within that 10-year window, those are kind of permanent exceptions to the Secure Act's death of the stretch. Whereas minor children are only considered eligible designated beneficiaries until they reach the age of majority. At the time they reach the age of majority, they stop being eligible designated beneficiaries and they flip to being designated beneficiaries. So in essence, they go from stop stretching distributions using the old rules to flipping and turning on the 10-year window at that time. So for argument's sake, oh, and before we give an example, let's cover what age of majority is. In the overwhelming majority of states, and this is a state law issue, but in the overwhelming majority of states, state law says you reach the age of majority at 18. One thing I'd note is age of majority and age of majority for like UTMA purposes are not always the same, and in fact are generally different. Most states have an age 21 age of majority specifically for UTMAs. Some go even further up through 25, whereas the overwhelming majority of states have an age 18. I think it's 46 or 47 states actually are age 18 for the age of majority. A few states are a little bit older. I think Alabama is age 19. Mississippi, I believe, is the oldest state in the country at age 21. But bottom line is most states are 18, which would lead you to believe that in most places, by the time the child reaches the age of 18, they're switching over and going from those lifetime distributions over to the 10-year window. The good news is that many of your clients' children or grandchildren, or children, excuse me, in this particular case, has to be a minor child. They would be, hopefully they would be going to school, maybe going to college, etc. And there is a treasury regulation that appears to apply here. The IRS or Congress referenced subsection F in the Secure Act. And then subsection F takes you to another section in the code that says, hey, go look at some Treasury regulations. And the Treasury regulations, as you typically know, if you've ever looked at the tax code or regs, you kind of bounce around. And it appears that a regulation that's out there that says if an individual is still pursuing a course of education, that they can continue being considered a minor for federal tax purposes here until they reach the age of 26. So through the age of 25. What is a specified course of action? We don't really have good guidance on that. So clearly someone in like college or pursuing a graduate degree or a postdoc, doctoral degree or something like that, where it's a bona fide, accredited university with a degree that's coming in. Yeah, clearly that's going to be pursuing a specified course of action. Will vocational work count? I tend to think so, but we don't really have clear guidance from the IRS on that. But bottom line, using that kind of delayed stretch, let's say that an individual was going to college and they were able to use the ability to continue on stretching as a student pursuing a course of study through at least the age or through up to the age of 25. If that's the case, and let's say they graduated at 22 and then stopped, went into the workforce, at 22, they switch over to the 10-year rule. So by 32, they're done. Before that, it's life expectancy rules. So for argument's sake, let's say a 40-year-old parent passes away and leaves it to the 5-year-old child. The 5-year-old child goes on to school until they reach the age of 22. From 5 until 22, they are going to follow the rules as if the Secure Act had not been passed. So beginning at age 6, for instance, the year after death, they'll take their first very small RMD using life expectancy rules. We'll continue to go on. They'll do at age 7, the same thing, age 8, etc. And finally, once they reach age 22 and they graduate, they're no longer pursuing a course of education, or simply if they just reached age 26, and even if they're still in education at that time, that exception runs out, they switch over, they go to the 10-year rule, and at the end of the 10 years, there's going to be nothing left in that account. All right, let's go ahead and move on here. And I see some of these questions coming in, which is great. I'm going to answer all the stretch questions kind of as we get to the end here. Here's your overview of the 3 different groups that exist now. We've been conditioned since birth, red, bad, green, good, yellow, kind of in the middle, right? Traffic light scenario. And that's kind of what we have here is like, red is still the worst treatment. You might say, well, is it really a big deal to name people on the beneficiary form anymore if they're not a spouse or a eligible designated beneficiary? The answer is yes. 10 years is twice as good as 5 years, right? Especially if you've got a large IRA. The last thing you want is everything coming out in 5 years. Doubling that is, every little bit we can do is going to help here. So let's talk about the impact to trust beneficiaries. And I see several of you have commented here about trust. So impact to trust beneficiaries. The general rule still is that, in fact, let me go back one slide and say as complicated as trusts were before, the sad reality is we just made them that much more complicated. Because if you look at the last item on each of these groups here, you'll notice that certain trusts is listed in every category, which means we now have to distinguish between a non-designated beneficiary trust, a trust that's going to be considered a designated beneficiary, and one that will follow the eligible designated beneficiary rules. So the impact to trust is that we first have to decide, which category they're in. As a quick refresher for those who are not super familiar with the way IRA or retirement account trusts work, in general, a trust is a non-designated beneficiary, right? So they have no life expectancy, and if you leave assets to a trust and the death occurs before the required beginning date, it would be 5 years. If it occurs after, it's remaining life expectancy of the owner. In other words, by default, they fall into that red category we just looked at, which gets the worst treatment of all. Now, that's what's in the tax code. When the IRS actually wrote the regulations, that's where the see-through trust rules came in. And essentially, the IRS realized, how are we going to make this so that no trust benefit? What if somebody has a special needs child or there's a bona fide need for a trust? We have to somehow preserve the stretch, if you will, for these individuals. So they came up with what are called the see-through trust rules. And the see-through trust allow you to look through the trust to the oldest beneficiary and to allow them to be treated or to stretch distributions using that beneficiary's life expectancy. So those rules, if you're not familiar, are simply that the trust be valid under state law, the trust upon death become irrevocable, that the beneficiaries of the trust are identifiable, and a copy of that trust needs to go to the custodian by October 31st of the year following the death, or a certified list of the trust beneficiaries. So if you're taking notes and you want, I'll just repeat that one more time. It has to be valid under state law. That's pretty self-explanatory and pretty easy. You have to be irrevocable at death. It has to be, or the trust rather, has to be irrevocable at death. The bennies of the trust need to be identifiable, and you have to fulfill a documentation requirement by October 31st of the year following the year of death. And if you meet those requirements, then you can look through to the oldest applicable trust beneficiary. Now, notice the way I just phrased that. The oldest applicable trust beneficiary, not the oldest trust beneficiary, the oldest applicable trust beneficiary. And the reason why I'm kind of sliding that weasel word in there, if you will, is that conduit trusts and discretionary trusts work differently in that regard. And you might be asking to yourself then, Jeff, what is a conduit trust? What is a conduit trust? How do I know when a trust is a conduit trust? Very simply put, a conduit trust is one which requires that at least the RMD go out from the inherited IRA each year and right on out to the trust. Okay? So the trust has no discretion. The trustee has no discretion. The trust in its language says, take the RMD. As the RMD comes out, at least the RMD, could be more, but at least the RMD must go out to the trust beneficiaries. And because the IRS knows at least who's getting the income today, they only require you to look at the current beneficiary of the trust. In other words, who's getting the income of the trust? If you say, for instance, I leave this trust to my spouse, and they can get the income and the RMDs for life, and then when they pass away, it goes to my adult children. Well, the spouse will be considered the life expectancy, and there it would appear, although we're still waiting for IRS guidance to confirm this, most experts believe now that that conduit trust should be considered an eligible designated beneficiary and look through because it's just the spouse's lifetime, and the spouse, him or herself, would be a designated beneficiary. Now, the other type of trust, a discretionary trust, is one in which it's simply not a conduit trust, right? So it could be a trust that says, hold the money in here until my kids reach age 30 and then give them half and then give them half again at 35, etc. It could be a trust where you say, I trust my trustee. Let them figure out how much to take out of the account and pass out however much they feel should be going out to the trust beneficiaries each year, right? And even if the trustee decides to take the RMD, and even if they decide to pass that out to the trust beneficiaries, well, in that case, it's still a discretionary trust because it didn't require them to do so. And the difference here, and the key that you need to be aware of, is that when you have a discretionary trust, it's not just that current income beneficiary, it's that whole list of future beneficiaries that you have to look at. Not only who gets it, but who could get it if that current beneficiary dies and there are other beneficiaries down the list. Which basically means that a discretionary trust will have an incredibly difficult time. In fact, it'll basically be impossible for the discretionary trust to qualify as an eligible designated beneficiary. because at some point down that list of future potential beneficiaries, it's going to list someone or something that is not themselves an eligible designated beneficiary, kind of spoiling those rules. Now, I mentioned to you earlier, Congress passed, or the House, I should say, passed the Secure Act, or a version of it, in June, overwhelmingly. The version that got attached to H.R. 1865, the appropriations bill at the end of the year, was almost identical to the version that was passed in the middle of the summer in virtually all regards. However, the biggest single exception was that someone, thankfully, got a hold of Congress and said, hey, if you write this bill the way you're talking about, you are going to make it so that special needs children can never stretch distributions, because by definition, the special needs trust can't be a conduit trust. If you automatically pass out the distribution each year, it's going to be taken by Medicaid or some other state or local benefit, right? So Congress created a new term for us. Wonderful, right? Another new term. You can see it here on the screen. The exception to this rule for discretionary trust is the applicable multi-beneficiary trust, a new term that we need to be aware of. And what does this say? First off, in order to be an applicable multi-beneficiary trust, all the trust beneficiaries, all of them, have to be themselves designated beneficiaries. And at least one has to be disabled or chronically ill. And what this applicable multi-beneficiary trust rule says is, if we have that situation, and let's say mom or dad leave everything to a single trust, and then at death, once the IRA is left to the trust splits out into separate subtrusts. And one of those trusts, or more of those trusts, one or more, is for the benefit of a disabled or chronically ill person. That separate trust that got split out after death can stretch using the disabled individual's life expectancy. Now, that is actually contrary to the IRS's longstanding interpretation that said if you have one trust, one beneficiary named on the beneficiary form, even if it splits out afterwards, we're not giving you separate life expectancies. We're just using one, the oldest of the master trust, because you only listed one beneficiary. This provision, because it's Congress, it's statute, overrides that previous IRS interpretation. The other one here would be simply if you had a beneficiary trust that was all for disabled or chronically ill persons, and that's less likely, but certainly possible. Okay, let's go ahead here and move on to what happens when a beneficiary passes away, which I believe was one of the first. Yes, so somebody asked here, what happens when a beneficiary dies? Is there a new 10-year window for the next beneficiary? If you're taking notes, I'm just going to ask you to add a third column here, or a third group. So on here, on the screen, you see death of an eligible designated beneficiary and death of a pre-Secure Act beneficiary. Okay, what both of those have in common is that they're both stretching, right? If you inherited before the Secure Act, the death of the stretch didn't apply yet. Therefore, you can continue stretching. On the other hand, if you inherited after the Secure Act, but you were in that special group of eligible designated beneficiaries, you get to stretch still. Here's the key and the simple answer to what happens when one of those persons die. The next beneficiary gets the 10-year rule. Okay, so there's no continuing of the life expectancy anymore. It's simply put, simple way to remember this, when a current stretch beneficiary dies, either because they were grandfathered into the old rules or they met the eligible designated beneficiary rules here, then the next in line beneficiary automatically gets the 10-year rule. Okay, that's pretty critical to understand. In other words, if you look at the last kind of sub-bullet point there on the top, an eligible designated beneficiary cannot they themselves have an eligible designated beneficiary. It doesn't matter who would get it after that. So for argument's sake, let's say you named a brother who was 7 years younger than you as your beneficiary. Well, they fall into that 10-year window category. They're an eligible designated beneficiary. Let's imagine that brother is now stretching and they die and they leave it to their disabled child. Guess what? Even though that child is disabled, they don't get to continue life expectancy of the decedent. They don't get to start their own new stretch period. They get the 10-year window because only you cannot have an eligible designated beneficiary of an eligible designated beneficiary. Just can't happen. So with that in mind, there is one exception to that rule, which I will point out, and it's if a young spouse or if a spouse dies before the deceased spouse would have been in previous law 70 and a half, now after the Secure Act 72. And the reason that's an exception is the rules treat the surviving spouse who dies, obviously no longer surviving, but if that surviving spouse dies who sets up the inherited IRA prior to when the first deceased spouse would have been 72, the law treats that surviving spouse beneficiary as if they were the owner of the account when they die. So the law treats them as the owner, not as a beneficiary, therefore they're not considered an eligible designated beneficiary. If, on the other hand, let's say you had a very young spouse who was, let's say, 40 years old, and there was a big age difference, and the deceased spouse was 75. Well, if that's the case, that special rule no longer applies because the deceased spouse was over 72. And if that surviving spouse themselves passes away, their beneficiaries would automatically be in the 10-year rule. One category you don't see here, I told you I wanted to add it, would be what happens if a beneficiary who inherits today as a designated beneficiary dies. So for argument's sake, let's say grandma dies today and leaves it to adult child who's 40 years old, lives 3 more years, and then sadly passes away themselves. They leave it to their own child. Their own child would finish out the balance of the 10 years. So once you get into the 10-year window, you don't get another 10 years when death occurs. You just finish out the 10-year span that you have. Okay, so let me take some of the questions that have come in here regarding the stretch, and then we'll talk about some strategies that we can do and some identification of key individuals. So first one, explain trust being named as a beneficiary. I think we covered that. And what do you feel our responsibility as advisors to review beneficiary designations for trust being named? This is a really good question. The second part of this is a really good question. What's the advisor's responsibility? The first thing I would say is this. It is certainly your responsibility as an advisor to understand who your clients name as beneficiaries and to understand that anytime you have a trust, it is going to add cost and complexity, right? This is my typical answer when someone says, should I name a trust as my beneficiary, is we've got to break out the old scales of justice, right? And on one side, I'm going to weigh cost and complexity. And on the other side, I'm going to have control. And that's it. I just need to weigh those things and decide which of these is more important to a client, right? And obviously, by virtue of the Secure Act, cost and complexity are potentially dramatically accelerated. For instance, you can see here on the screen, I said, prioritize trusts that are beneficiaries. Like in terms of who you should go back and contact first, yes, the advisor's responsibility should be to know who has a trust as their beneficiary and to at least have a basic understanding of how IRA trusts work. And I think and I don't know whether the question here is saying legal responsibility or moral responsibility / what we should be doing really as, leaders of the industry and trying to be the best of the best, right, which is the goal. And I would say legally, frankly, there's probably not much of an obligation there other than to know who the beneficiary is and to have discussions with the client about that. Other than that, you can say, talk to your attorney, talk to your attorney, talk to your attorney. The reality is, as many of you have probably experienced, the attorney in most instances talks either above the client's head or the client leaves the attorney, comes back to your office and says, my attorney said this, what does it mean, right? You've all experienced that before. And so I think our moral obligation as advisors is to really help the client understand that frame. That's a simple conversation in essence, right, is cost and complexity versus control. But it could end up being an hour-long or multiple-hour conversation in terms of really diving through that. So for argument's sake, I would make sure that you have a valid understanding of what a conduit trust is, what a discretionary trust, and understand how the client's trust will work. For instance, many conduit trusts in the past had language that was something like this. Take only the required minimum distribution each year and pass it out to the beneficiary. Right? So conduit trust means whatever comes into the trust has to go out, but the owner wanted to essentially force the stretch. So it said, whatever comes, take only the required minimum distribution, then pass that out. Well, let's think about how that framework of a trust would work in the current environment. In the past, if you left that IRA to, let's say, a 30-year-old beneficiary or 40-year-old individual, they would start taking out like 2.5% each year and passing it along to the beneficiaries, right? Like no big deal. Today, right? Remember, The 10-year rule applies. When or how many required minimum distributions do we have? One in the 10th year. So basically, a trust that was worded like that, which is not uncommon in the past, is now saying, after I die, make sure nobody touches anything in my IRA for 10 years. Let that tax deferred monstrosity continue to grow. Think about what happens over a 10-year period. Basically, you can imagine it would double, right? Let's say 7% rate of return, which is reasonable. Over a 10-year window, we're doubling that count. So somebody inherits $1 million and it goes to that conduit trust that says take only the required minimum distribution, and it has to go right out to the trust beneficiaries. That trust is now saying, take nothing for 9 years, wait until the 10th year when we now have a $2 million problem, take it all out in one fell swoop and give it out to the trust beneficiaries. Not only is that going to be highly tax inefficient, but we have no more protection for those assets after the 10-year window. So you say, Jeff, okay, well, what if we go with a discretionary trust? Is that better? Potentially, but also think about this, right? In the past, small distributions, you could allow the trust, to only take those small distributions. And even though trust tax rates might apply, it wasn't a giant amount of money going into the trust. Take even a $500,000 IRA today that's inherited, that is spread out, let's say, evenly over 10 years. If you factor in earnings, let's say that, realistically, you've got to take out like $65,000 a year or something like that to evenly spread out the income. If you do that, and if, let's say, you have a discretionary trust that either requires the money to be held in the trust, or the trustee just decides that it's the best thing to do at the time, then this year, anything north of $12,950 that's held in the trust is taxed at the highest rate, 37%. And that's before you get to state and local taxes. So essentially, because we're accelerating those distributions, we're accelerating the impact of trust tax rates. And frankly, if you've got trusts that are, at 37% for the majority of the income, and you tack on state and local taxes, you're basically giving away half potentially to taxes already. You have to ask yourself, like, if I actually gave this to the beneficiaries, how bad could they do on their own, right? I'm protecting it for them, but I'm already giving up half. I'd rather see them blow it somewhere than see it, go to the IRS. So these are just the type of conversations that you want to have. So I think a basic understanding of how your client's trust works, you can get most of that simply by a plain reading of the trust. And then encouraging them to go back and visit their attorney, right? If they really want the trust, if control is the most important thing for them, they should absolutely, urgently be contacting their attorney to review how their trust will work in light of the Secure Acts changes. Excellent question there. Thank you for asking that. One here, furthering question on trust for beneficiaries that pertains to minors and 401ks. How do you structure to protect minor children? You can use the trust, in either way I just mentioned. You can go with either the conduit trust or the discretionary trust. I would generally, I'd say it goes back to cost versus complexity, and the more control you want, meaning the discretionary trust, the more control, the more cost you're going to have to be willing to give up. Something you can consider for smaller accounts for minor children would be to, instead of using a trust, use an UTMA account. Name the beneficiary in the beneficiary form as John Smith as custodian under the Uniform Transfers to Minors Act of Missouri for the benefit of, Sally Doe, something like that. And this way, yes, at some point, whether it be 18 or 21 or as late as 25 under some state laws, that beneficiary will have full right to those assets, but at least they're protected until they reach the age of 20, at least the age of 21. Okay. Next here was husband already passed away and the IRA has moved to his wife. Wife has Alzheimer's. Does this qualify for an eligible designated beneficiary to her kids? In all likelihood, the answer would be yes. I think what you're looking at there first would be, is this in the spouse's IRA? Did you do a spousal rollover? If the answer there is yes, then her kids could presumably, now, I guess the question is she an eligible designated beneficiary? The answer is yes. If she inherited after the beginning of this year, otherwise the rule didn't exist. If it goes to the kids afterwards, the kids probably won't be eligible designated beneficiaries. I'm going to assume, since the husband passed away and the wife has Alzheimer's, that they're probably older. Their kids are probably not minor beneficiaries, so they would be stuck with the new 10-year rule. Another one here, should a minor be named as a direct beneficiary to avail themselves of the stretch provision? You can do that. Again, I would likely name the UTMA as a custodial account, because if you name a minor, particularly if it's the second death, or if let's say divorced parents, but the other spouse is not going to be the guardian, you get into having to go to state law then to name or state court to name a guardian, which can be a little bit problematic. If the child turns 26 or finishes school, is it 10 years from the event, or does it revert to 10 years from the decedent's death? It's 10 years from when they are considered to reach the age of majority, which would be either at the end of school or upon reaching age 26. So in that case, it would be from 26 to 36, the 10-year window would apply. What happens if you list a donor-advised fund as a beneficiary? Nothing. You give your money to charity. But typically, a donor-advised fund, if it's yours, once death occurs, there's going to be some rules around that. Well, more often than not, you just leave it directly to the charity. You don't really need the donor-advised fund at that point, since you've passed away. And when does the ghost life expectancy apply? Maybe you could just clarify that. I just want to make sure I understand what you mean by ghost life expectancy. Okay, so let's go ahead and move on to our next topic here, so we can cover the other things that are critical changes to the Secure Act. RMDs now begin at age 72. So we've pushed back the starting age for RMDs from age 70.5 to age 72. Obviously, the required beginning date is similarly pushed back from April 1st of the year following the year a client turns 70.5 to April 1st of the year following the year they reach age 72. Notably, though, this change is only effective for those turning 70.5 or older in 2020. So many of you, and probably all of you, or at least the majority of you, have at least one client who turned 70 last year, who was also 70.5 last year, but will only be 71 this year. And they might be thinking to themselves, ooh, I don't have to take an RMD. They do. Because they were already 70.5 prior to the start of this year, they still have to continue taking required minimum distributions. One thing I would do, however, is for those of you who have clients who are turning 70.5 this year, I would absolutely get on the phone with them or send out an email or some other communication to them and make sure that they realize that the Secure Act passed and they don't have an RMD. Because guess what? They may be getting letters from their custodians saying, you have an RMD for this year. Because the Secure Act passed so late, many custodians and IRA administrators, et cetera, had not enough time to update their systems and stop the letters that said you have an RMD from going out. And in fact, last Friday, the IRS came out with guidance and relief for the custodians, but not individuals who relied on the custodian's advice. One of the things, I've reached out to the IRS already and tried even on social media to get them to respond or something like that, because it seems very unfair. They basically said, yeah, if you're a custodian, you made a mistake, just send a corrected note to the client by April 15th, and we won't consider you as being in violation of your rules, right? Or not meeting your obligations. It'll be okay. But what if a client gets the letter today and they act on it thinking they have a required minimum distribution? What if they don't realize that until they get the corrected letter on April 15th? It's beyond 60 days. What if they've already taken another distribution in the last 365 days that they rolled over? Even if they caught it now, they wouldn't be able to fix it. So make sure you get on the horn with your clients and let them know that if they are 70.5 this year, they do not, in fact, have an RMD, even if they get a letter to the contrary. And another note here, it does not change the age at which QCDs can be made. QCDs can still be made at age 70.5. Now, you might say, why would I do that? Well, if you're going to give to charity, giving away pre-tax dollars is not a bad way to go about doing it. It's just not going to lower your RMD because you don't have one until you're 72. A quick way of knowing how this impacts your clients, very simply, if their birthday is January 1st to June 30th of the year, they now have 2 more years of tax-deferred growth, no RMDs, compared to the old previous rules. If, on the other hand, they are a second half of the year birthday, so July 1st to December 31st, they have 1 more year of tax-deferred growth or pushing out the RMD before it kicks in. So that's a quick way if you want to know. Client says, how am I impacted by this? Just, hey, what's your birthday again? Oh, March. Oh, you get 2 more years before you have to take an RMD compared to the previous law. And obviously from a planning perspective, what does this mean? Simply put, it means that the RMDs, we don't have them. It gives us more ability to do, let's say, conversions at lower income levels, et cetera. And just a quick note here that the proposed life expectancy tables that the IRS put out last year are expected to be finalized this year, but have not been so yet. So it's not a changing of the factors. It's just that we don't use the age 70 or 71 factor anymore. Some of the side effects here, simply put, I mentioned those special rules for spouses. Those get pushed back to age 72. And as we said before, there's no direct changes to the rules for non-designated beneficiaries when they reach when they inherit an IRA. However, there's an indirect impact in that death occurring prior to the required beginning date is now death up until a later point, right? Instead of being April 1st of the year after 7.5, it's April 1st of the year after 72. And so with that in mind, more non-designated beneficiaries will be stuck with the 5-year rule because it applies until a later date. Maximum age for traditional IRA contributions has been repealed. This one's pretty easy. All you need to know is that there's no more age limit on traditional IRA contributions. So anybody at any age can contribute to an IRA. And this is nice because it simplifies things. Prior to the Secure Act, we did not have, this was the only account, in fact, that you could not make a contribution after 7.5. Could have made them to Roth IRAs and SEP IRAs and simple IRAs and 401ks and all those counts. The traditional IRA was the only account that you could not do a contribution afterwards. And it's now eliminated, which is good news for those who are either still working after 7.5 or those who have a spouse who's still working and they are over 7.5 and can do spousal contributions. Just a note to give you some perspective here on, like Jeff, how many people does this really apply to? Statistically, it's about 32%. So roughly a third of individuals who are 70 or older are actually still in the workforce. So it actually is a significant percentage of the population. But while IRS giveth with this nice new, or Congress, I should say, giveth with this nice new simplification of the rules that kind of harmonizes the age limit or lack thereof with every other account, Congress also taketh away in the form of the new Qualified Charitable Distribution Anti-Abuse Rule. In short, what Congress was worried about was that people would use this newfound ability to contribute after 7.5 and use it to get an artificial charitable deduction. For argument's sake, let's say your client is 72 years of age today and they're still working, but they don't itemize. So they wouldn't get a benefit for giving, let's say, $6,000 to charity. Congress was concerned that instead of making a charitable contribution, the individual would first decide, you know what, I'm still working. Let me make a deductible traditional IRA contribution. I will put it into my traditional IRA account, take a deduction, and then right afterwards, I will use the QCD provision to give it to charity, thereby essentially getting around the limitations of a itemized deduction, or rather the charitable contribution deduction, which would be both that you have to itemize and also that it's a below the line deduction, so it does not limit things or reduce things like Medicare Part B premiums or help with other phase outs or phase ins key to AGI, whereas the IRA contribution deduction is above the line, so it would. So I have to say, while I understand Congress being concerned about that, first off, if you're high income, you can't take the deduction anyway in most cases because you're going to be phased out. You probably have access to an employer plan. So that's not a big deal. Second, it's only impacting people, right? This only impacts people who are 7.5 years of age or older, who are working, who make contributions to an IRA, and then, and this is the key, and then decide to give that money away to charity. Right? Like, is this what we really needed an overly burdensome and overly complex rule for? I say no, but it doesn't matter what I say. It's here. And you need to understand how this rule works because it really negates the value of making post 7.5 deductible contributions for individuals if they ever want to make a QCD in the future. So here's the language right from the text. Obviously, I've highlighted and underlined some things that are key. But what this is essentially saying here, that first, by reason of the preceding sentence, what it's saying is, if you were going to treat something as a QCD, right? If something met the QCD rules as defined above, then don't treat it as a QCD to the extent that there have been post 70 and a half deductible traditional IRA contributions. And in essence, what happens is the Secure Act's anti-abuse rule rejects those QCDs as QCDs until you burn through your quote unquote bad post 70 and a half deductible traditional IRA money. That's a mouthful, so let me try and give you an example to make this a little bit clearer. Let's say your client is 70 years of age and turning 70 and a half this year. This way, there's no required minimum distribution, right? They get till 72, which would be in 2022 for them. And this year, they're still working, and they decide, you know what? I'm going to make a $7,000 deductible traditional IRA contribution, and so they do that. And next year, they're still working, and they do it again, and they make another $7,000 deductible traditional IRA contribution. So now they've got $14,000 of deductible contributions in their traditional IRA made at or after the year they reach 7.5 over here. The following year, let's say they've retired, they're 72 years of age, they now have to take an RMD, and hypothetically, let's just make a $10,000 RMD, okay? And let's imagine your client is very charitably inclined and they say, you know what, I'd like to give this $10,000 to charity. I'll make a QCD. Even if they follow all the QCD rules and they give it right to charity, it's not going to count as a QCD. It will first go to reduce these $14,000 of bad post 7.5 deductible contributions. So $10,000 comes off. This $14,000 gets reduced to $4,000. The $10,000 would-be QCD is denied QCD treatment. It's still treated as a regular distribution, followed by a regular charitable contribution, which, as many of you realize, is not nearly as beneficial because your client may not itemize, it's going to impact their AGI, etc. The following year, let's imagine they have another $10,000 RMD and they do the same thing. They make what should be, in normal situations, a true QCD, but they still have that $4,000 of bad money left. Well, the first $4,000 of the QCD, or fake QCD, if you will offset that $4,000 over here, leaving $6,000 to be actually treated as a QCD. The other $4,000 will get that worst tax treatment of treated as a distribution, followed by a contribution. And only after you burn through all of those bad post 70.5 dollars do you then get back to your good quote unquote IRA money that you can use to make a valid QCD. So that's kind of an explanation here on the next slide of what I just went through with you. I want to go through some strategies to beat this though, right? For those of you who are like, wow, that sounds really lousy. Let's figure out how not to deal with that. Well, one way would be just don't give away, don't use QCDs. Give away highly appreciated assets, etc. Unfortunately, that's not a very effective solution, right? It's like most clients are going to be benefited if they want to give to charity by giving away the QCD, an entirely pre-tax asset that will not get a step up in basis when they pass away. And if they're over 70.5 already, let's face it, that step up in basis is not 50 years in the future. It may still be 20 years in the future, but it's not 50 years in the future, right? So better to potentially keep other assets that may get that step up in basis. Some other things, if your client already made a contribution or makes one before they realize the impact of this rule, you can simply remove their post 7.5 deductible contribution as an excess contribution as long as you do it in a timely manner, which is October 15th of the year after the contribution is made for. And then finally, you can burn through prior year's traditional IRA contributions. If you did this and you find somebody a couple years from now, you run into them and they say, oh, I didn't know, but I want to make QCDs. Well, even though they won't qualify and you'll still have to burn through the bad dollars, you still want to act like you're making a QCD if they ever want to do one in the future. And the reason why, I'll just go back here to that first slide on this subject, which was from the tax code. If you look at this first sentence, it says, by reason of the preceding sentence. If we weren't going to include stuff in income by reason of the preceding sentence, which basically is saying in lay terms, if you were going to exclude something from income because it was a QCD, don't include it or include it rather in income if you have these deductible contributions. But that first part, if you weren't going to include it in income because it would be a QCD, well, if you don't make a QCD, it stands to reason you never get to this anti-abuse rule, meaning that if you just took a distribution and wrote the check to charity, The tax impact for that 1 year would be the same as a rejected QCD, but you would actually not be burning through your bad dollars because you wouldn't have rejected a QCD by reason of this rule. So best to always follow the QCD rules. Of course, none of that is very satisfactory for clients who want to continue to contribute to retirement accounts. So what else can we do? Well, number one, if they're over 7.5, so what? Make contributions elsewhere. Use the SEP IRA, use the simple IRA, use a 401k if they have one. Contribute elsewhere. Also, you may have noticed that it said deductible traditional IRA contributions. So don't make deductible contributions. Make a contribution to a Roth IRA. No deduction, no impact to the anti-abuse rule. Or in some cases, if the client is high income and they can't make the Roth contribution, make a non-deductible contribution to a traditional IRA. And for those of you that have clients that are married and they say, look, we'd like to make deductible IRA contributions on top of our plan contributions. We've already maxed them out. We've got a lot of income, but we do want to make QCDs. Maybe you use what I'll call the divide and conquer approach, which is one spouse's account we use to make deductible 70.5 or older traditional IRA contributions, and the other spouse's account we use to make QCDs. Because if you look back at that slide I showed you before, it says to the taxpayer, not the tax return. And the IRA belongs to the individual taxpayer. So you can kind of split that aside for spouses. For some people, that may be the best of both worlds. It's simple and at least gets some extra money into a retirement account after 70.5. All right, I'm going to go through some other items here. I do see a QCD related question. QCD, if the client has a 401k and contributes to it and they have an IRA, can they contribute to the 401k and do a QCD out of the IRA? Yes. So that's one we just covered. The answer is yes, that's not impacted there. What about contributions to SEP? Those don't impact the QCD rules or the anti-abuse rule. However, note that you cannot make a QCD out of an active SEP. An active SEP is one is defined as that's continuing to receive contributions. So if you want to use SEP money to make a QCD, can you do it? Yes, but it takes an extra step. If you don't have other traditional IRA money, what you first need to do is put the money into the SEP, then move the money from the SEP to a traditional IRA, then do the QCD from there. Does the QCD anti-abuse apply to a person's IRA in aggregate or individual IRA accounts? It's in aggregate. Kind of like the pro rata rule applies to all IRA accounts. Same thing here. It's all accounts lumped together. So you can't put a deductible contribution in one account and then do a QCD from another account. It'll be looked at in total. Okay, some other ancillary items here. The rest of everything we're going to talk about we'll move through much quicker, but just a note that I want you to be aware of these provisions. The first one is that there is a new 10% penalty exception for childbirth or adoption of an individual who's less than 18 years of age. And what this exception does, it allows a parent to, after the date of the event, so after the birth of the child, or after the adoption, to within the 1 year period following that date, take up to $5,000 from their account. And it can be from each spouse's or each parent's, I should say, accounts. And each child triggers a new kind of a new distribution rule. So if you each did $5,000 for a previous child, you can do $5,000 again for the next one. And notably, some people have asked, so what expenses qualify? Is it like diapers, formula? There are no like qualified expenses here. It's if you had this event, then you can take up to $5,000. So if you had a baby or if you adopted a child that was under 18, you could take up to $5,000. Whatever you do with that money is up to you. You want to go on vacation and say, my goodness, that was a lot of work. I need a break. So be it. Like, that's your prerogative. Of course, the regular tax rules apply, so it's just a penalty exception. And then note on the bottom here that those distributions can be repaid, but the Secure Act is not very clear in terms of the timing of that. And I think we're going to need some IRS guidance. All right, our next Secure Act change, what I like to consider the Henry VIII rule. Some of you maybe remember the old song, I'm Henry VIII, I am, and he goes, second verse, same as the first. Well, that's what happened here with the Tax Cut and Jobs Act. Some of you may be familiar with, prior to the Tax Cut and Jobs Act, the kiddie tax, which is the tax on the unearned income of certain minor children, and you can see who that applies to here. That this is who is applicable to the kiddie tax. This is on the screen now. Those individuals will they were subject to tax at the parents' rates. It was basically a stopgap to stop rich people from giving money to their kids and having them pay interest and dividend tax at their own child rates. The Tax Cut and Jobs Act said, no, change that, make it taxable at trust tax rates, which, as we just learned before, are not very good. And for most children, this was a real damaging, it cost them more money, right? The problem was that, particularly with Gold Star families, their children were receiving potentially some benefits and getting smashed by the kiddie tax rules. And so Congress decided they were going to adjust these rules. And instead of just carving out an exception, which was kind of first thought out about for the children of Gold Star families, they just said, you know what, let's just go back to the old regime. Forget what we said. Second verse, same as the first. We're going back. 2020, it's all taxable at the parents' rates. But, and here's the big but, for 2018 and 19, you can choose. Now, clearly, clients have already filed for 18, but in many instances, one of the things you should be thinking about is which of your clients' children or grandchildren may have filed or may have been hit with the kiddie tax in 2018, and it may pay to go back and amend that return and throw that income on the parents' tax return, or at least be taxable rather at parents' tax rates, so that you can get out of the trust tax rates for that income. All right, change number 7, open MEPs. Simply put, prior to the Tax Cut and Jobs Act, you probably didn't see a lot of multiple employer plans, which is basically a single retirement plan that multiple companies can essentially like plug themselves into. So for argument's sake, you could create like the BAM multiple employer plan. And instead of every single one of your clients, or instead of you having to help every single one of your clients create a unique plan and maybe use unique funds, etc., they could all plug themselves into the BAM multiple employer plan. The reason you didn't see a lot of this in the past, and you could imagine the economies of scale and the efficiency that would create. The reason you didn't see a lot of this in the past was 2 reasons. One, the IRS had what was called the one bad apple rule, which essentially said, hey, let's say 50 companies decide to plug in to the BAM multiple employer plan, the MEP. If one company didn't follow the rules, the entire plan would have been disqualified, and all other like 49 companies would have lost the qualification of their retirement dollars. Really ridiculous rule, right? Like, who would want to subject their own employees and potentially their own retirement savings to the whims of people and companies that they don't even know exist? Thankfully, the Secure Act fixes that and says, okay, IRS can give cure procedures. We can get rid of the one bad apple only and allow the rest of the plan to be preserved, if you will, its tax-deferred status. The second issue was that ERISA has always contained a nexus requirement for participation in a MEP. For many years, in fact, up until the middle of last year, that nexus requirement was deemed to be like essentially common business. So financial advisors in different areas could have participated in one MEP, but a financial advisor and an accountant could not have. Last year, the Department of Labor decided to reinterpret that nexus requirement and said, you know what, it's not just same businesses, it's same type of business or same geographic area. If you're in the same state or municipality, we'll let you participate in the same MEP. However, the Secure Act makes that null and void because it just removes the nexus requirement altogether. So now you can have a MEP, let's say, that has, a fisherman in Alaska part of the plan, that has a contractor in Florida part of the plan, an accountant in New York, and a financial advisor in California. And they can all participate in the same plan with the same provisions, with the same investments, and with any hope, the goal is to reduce costs of the plan and make it easier for employers to adopt them. That's the goal of the MEP. That's why you see these being open. Change number 8, annuity-related changes. I know there's probably a couple of you grumbling in the room already. Let me give you kind of the overview of what these changes are. Certainly, the Secure Act was passed. I don't think there's any question because the insurance lobbyists pushed it through, right? So this is going to be good for the insurance companies. Why is it good for the insurance companies? Because it really opens the door to annuities inside 401ks that weren't there before. Now, in fairness, there's a lot of research out there that supports things like SPIAs and QLACs, et cetera, being really, really valuable in mitigating longevity risk. The problem, though, is that not every annuity is a great annuity. I think everybody's aware of that. Historically, you didn't see a lot of 401ks with annuities in them, even though they could have used them as an option. primarily due to two factors. The first was fiduciaries were worried, like, what if something happens 20 years from now to the insurance company? They go belly up. I don't want to be sued, right? I'm personally liable. I don't want to be sued. The Secure Act removes that risk or severely limits it by creating a new safe harbor for those individuals. And there's two requirements of the safe harbor. The first is you have to review the capability of the insurer to satisfy its obligations. Basically, hey, can we be sure that if we're putting you on the platform that you'll actually be able to pay these future income obligations? That's good. I think that's a fair requirement to meet this fiduciary, or rather the safe harbor for meeting the fiduciary requirement and doing due diligence. The problem, though, and what is really egregious in my opinion, is that the way this can be done is by asking the insurance company, did we meet our, can you meet your obligations? That's kind of like getting the fox guard the hen house. And yet that is what allowed here. The second thing is that you have to determine that the fees are reasonable. Note that there is no requirement to select the lowest cost provider. The cost just has to be reasonable. In fact, Congress wanted to emphasize that so much that there is actually a section of the Secure Act, a subsection that says, quote, no requirement to select the lowest cost option. So it is explicitly written in the law that that is not a requirement. The other reason that you didn't see annuities in plans for many years was that what happened if I was actually comfortable enough originally to put the annuity on the platform, but then I later decided, I don't know if this insurer is really good anymore. I don't think I trust them. I want to boot them out. Well, how do you get rid of them, right? If you want to get rid of like company A small cap and put company B small cap on your plan, it's very easy, right? You map participants from the old investment to the new investment, kind of done. But if you get rid of an annuity, what if there's surrender charges? Some annuities don't even have any surrender value. Like, how would that work for participants? It would have been a nightmare. The Secure Act resolves that by saying if the company wants to get rid of the annuity as an investment option, well, 90 days prior to its elimination, that annuity can be kicked out from the plan and rolled over directly to an IRA, even if the individual is not otherwise eligible for a plan distribution. So that annuity itself can get rolled over and be held as an IRA annuity. All right, and then there's also a new disclosure item. I'm not going to spend too much time on this because frankly, your clients probably don't read most of the disclosures they get already. But going forward, plans will be required to tell the clients what their lump sum value in their plan is worth in monthly dollars. Okay. Change number 9, there is a new small business retirement credit. It's actually an old credit that is enhanced. The old credit said if you establish a retirement plan as a small business, you could get up to a $500 credit. Small business is defined as a company with 100 or fewer employees making $5,000 or more each. And now that credit is enhanced and expanded up to $5,000. You can see the formula there on the screen, and all these slides are available for you. So if you need this, you can go back and reference it. There's also a new credit that says if you would also adopt a plan that has auto enrollment, we'll give you another $500 credit, which could be on top of your new plan credit for using an auto enrollment feature. Okay. Now, some other changes to qualified plans, either a little bit smaller, but again, just things you want to be aware of that occurred. The maximum contribution percentage for auto enrollment. So when a plan says, hey, we're going to by default put this much of your salary into the plan, the plan can increase it now to 15% after the first year. It used to be capped at 10. Now after the first full year, that can be increased to 15% by default. An employee can always, of course, opt out. The second one here is one you're going to want to note, excuse me, for your employers that you work with. And that's in the past, an employee was eligible by mandatory eligible to participate in a 401k if they met 1,000 hours of work in any 1 year, right? Going forward, that requirement still exists, but instead of just the 1,000 hours in 1 year requirement, Congress said, well, what about people who consistently work like 700 hours a year? They're never getting in to be a part of the plan. So going forward, there's a new requirement that says if you work instead 3 years in a row of 500 or more hours, you are also mandatorily eligible to participate in the plan. Now, the good news for those of you who have employers, you don't have the 500 hours starting until like this year. So we're not going to have, it's not like somebody's going to look back and say, oh, I had 500 hours for the past 3 years. I'm in your plan in 2020, surprise. So employers do have a few years of time to prepare themselves, but they should be aware of these additional potential costs if they're going to have more employees participating in the plan. And just to note that the individuals who are in the plan by virtue of that 3 years of 500 hours requirement, they can be excluded from testing, which is good because if you're only working 600 hours a year, you probably don't have the ability to contribute that much in the first place. Item number 3 here, thank goodness, no more 401k debit or credit cards. If you're not familiar with what this is, in the past, some plans actually gave participants like debit or credit cards and basically said, hey, you want a Starbucks latte? No problem. Put it on your 401k. You'll create a microloan. Not a good situation. Those are removed. And the last one here, item number 4, is a significant provision for you beginning next year. It's effective for this year, but it really doesn't impact people until next year. And that's similar to the way that you can establish a SEP after year end and fund it for the prior year. You can now also do that with stock plans, pension plans, profit sharing plans, and annuity plans. And this is fantastic for your small business owner who has like let's say a much better year than they thought. They can now go back and retroactively create a pension plan, for argument's sake, and store a ton of money away in something like that. Now, what you notice is they're all employer-only funded plans. So it's not like you can still go back and do a retroactive 401k or something along those lines. It's just those plans that I've listed for you. 2 more types of income can be used to make IRA contributions, specifically taxable non-tuition fellowship and stipend payments. So if you've got clients with children or grandchildren who are in, let's say, post-grad work, and they're getting a stipend, they can now use that to make IRA or Roth IRA contributions. And then difficulty of care payments can be used to make non-deductible only, traditional IRA only contributions. If you don't know what those are, in short, some foster parents who foster particularly challenging children, whether it be for mental or physical difficulties, they receive excess payments from the state that are generally excluded from federal income tax. Those payments can now be used to make non-deductible, again, only traditional only contributions. And finally, our last provision here is that that there's a new provision for 529 plans to be used to pay the student loans of an individual up to $10,000 lifetime amount. And that can be used to pay either principal or interest. And we have a $10,000 lifetime cap that the individual's 529 plan can be used to pay their qualified student debt. In addition, and without changing the beneficiary of the account, you can also use up to $10,000 of that individual's 529 plan to pay down the qualified student debt of any sibling of the 529 plan beneficiary. So those are your various Secure Act rules. I'm a corny guy, and Tim said, I'm the Secure Act guy. That's kind of a weird thing that happened after the Secure Act. I tweeted a bunch of things, and all of a sudden I got a lot of you have to talk to that Secure Act guy on Twitter. So that's kind of that's my little S for Secure Act guy. I want to thank you all for joining me. I do see a couple questions here that I will answer with the couple moments we have left. And the first is the post 7.5 QCD anti-abuse rule measured by contributions or contributions plus growth? Just contributions. The 10-year rule, again, you said a beneficiary falls in the 10-year rule and they die, the child would only get the remainder of the parent's 10-year rule. Correct. Essentially, once the 10-year rule starts, you would only be able to finish the 10-year rule with future beneficiaries. And the last thing I will say to you is, because I know probably so many of you are still, figuring out what to do with these, the stretch and how do you deal with it. The things you want to look at now are potentially like Roth conversions during the owner's lifetime. Some of you may want to look at charitable trusts to replicate the stretch for individuals. You may have clients that decide, instead of leaving everything to my child, I'll leave 70% to my child and 10% to each of my 3 grandchildren, because if I can't make more years for them to stretch distributions over, I'll make more people and more tax returns for them to stretch distributions over. These are all things that you may consider. And the last point I'll make about that 10-year rule is that for many of your clients, they can actually make it an 11-year rule, because remember, year 1 doesn't start until the year following the year of death. So if someone dies today, there's plenty of time to establish an inherited IRA and get a distribution out before the end of the year. And that would get us 11 tax years, because this is really year zero. Year one doesn't start until next year. So spreading that income out over as long as possible, or in the years where the client has the least amount of income or highest deductions, is still going to be the, maybe the best strategy. And frankly, it gives us more work to do, which is always a good thing, more opportunity to help clients and make a difference and impact their lives. So with that, I want to thank Tim, Kelly, Caitlin, and all of you for joining me for this. I hope it was productive, and I hope you got some value out of it. If you have questions, feel free, reach out, Twitter. You can email us here on the screen. I'm happy to answer as many questions as I can possibly get to. Wish you all the best of luck for a wonderful 2020, and have a great rest of your winter conference. Bye-bye, everybody.